Good morning, everyone. This is Eric Rodevois from EPGD Business Law. So I'm feeling inspired. This is off the cuff, and what I want to talk about is basically the thing we always talk about, and it's the importance of contracts. Okay? Now, this is a true story. One of my clients who, fortunately, a few years ago, came to me and asked me to draft them a package of template employment contracts. And what we did is we reviewed the type of employees they were going to have. So we had their administrative employees, we had their sales employees, we had their managerial employees, etc. And you can see. So we came up with one basic model of what we wanted in our employment contract, and then we created specific templates for the different types of jobs. So for example, the managerial people were paid a salary. The administrative people were paid hourly with the right to overtime. The salespeople were paid a commission. And then what we tried to do was specify different types of benefits and bonuses, etc. And they're made to be pretty flexible. The idea is that the client's going to have a template Word document that they can go into their computer and update. They don't need to call their lawyer every time. Now, if they're going to make a new big change, or if they discover something that doesn't work or something that they think might work better, then they call their lawyer and we make revisions. So here are the couple things that I just want to make very clear are typically included in an employment contract. Okay, now we can do a lot of these same things for an independent contractor agreement, but let's just stick to employees for now. Okay, so one of the most important things is we're going to include a confidentiality clause. Okay, and what that means is that the employee has to keep all the company's secrets. Okay, we also call that a non-disclosure. Okay, now next we're going to have a non-compete. This one's really important. If it's not in a contract like this and there isn't consideration, and typically the consideration is, hey, if you want this job, you're going to sign this contract. The consideration is I'm going to pay you money. So we have a non-competition. Now the law on this is tricky. Typically we like to think of non-competition clauses in terms of time, geography, and what they're actually prevented from doing. So for example, my secretary, when we were negotiating her employment contract, she said, listen, I feel really uncomfortable signing a non-compete because, you know, I got to look out for my kid and I got to make sure I can make money. And I said, all right, here's the deal. You can go work for any law firm as long as they don't do what I do. So there's about 30 different areas of law. Go work for one of the other areas of law. Don't go work for a corporate law firm. All right? So if you want to go to family law, I don't care. Personal injury, I don't care. Criminal law, I don't care. So non-compete. Then we can have what's called a non-solicitation. Non-solicitation refers to the clients. So don't go after my clients after you leave. And then lastly, what we'll have is what's called a non-interference. That one means don't try and convince any of my other employees to quit with you, right? So if you're gonna leave, so let's just say, just in an example, non-competition for 2 years within 5 miles of my company, you can't work for another business law firm. Okay, so they move to the next county over, so they're outside the geography, which means they can do whatever they want. But they start making phone calls to all my other employees and saying, hey, I got a better deal over here. Why don't you quit working for Eric and come work for me? That would be that would violate that. We also like to include a non-disparagement, right? Don't go around saying anything bad. All right, now let me tell you what happened. So my client calls me and he says, Eric, one of my employees just quit, went to go work for the competition, and is calling up my clients and my other employees and trying to get them to quit with me. And quit with them. And so my first question in every one of these situations is, did you have a contract? And he goes, yeah. Remember you drafted them for me? I go, yeah, well listen, a lot of times I draft them for my clients. It doesn't mean that they have the discipline to actually sit down and use them. And he goes, no, don't worry. I followed your advice. All of my employees sign all these things. And I said, awesome. So let me just tell you in the last couple seconds that we have. All of this is included in a contract. Some of these exist whether you have a contract or not. And the one that exists whether you have a contract or not is a fiduciary duty to your employer. There is a bond between employee and employer. But all of this has one magical little benefit: attorney fees. So if we decide to start a lawsuit against this employee, and now we're going to start with a cease and desist letter, remind him of his obligations, and hopefully he'll stop behaving badly. But If we have to go to court, at least my client has a good chance of getting their attorney's fees back at the end. Once again, this is Eric Rodebois from EPGD Land. Thanks for spending 5 minutes with me.